All right, good morning, everyone. We will just give a few more stragglers time to come in. Thank you for joining us today for this week's Q&A. As we always start, some housekeeping and instructions. As usual, this is general information and not legal advice, so please don't try to use it as such. And if someone comes to you and says, well, condo law said this, just know that it's not legal advice. You can only get legal advice from an attorney in a private attorney-client setting that you have a relationship with. So even if you are one of our clients, this is still not legal advice. Please put any questions you have in the chat down below today. We will probably have time to get to some questions if you think of them as we go along today. WSCAI has released a WUCIOA resource guide for sale. The proceeds from the sale go to support the Legislative Action Committee, who works with the legislature in Olympia to draft legislation and a bunch of other things regarding legislation. You can contact WSCAI.org to learn more. If you're going to CA Day, they will probably have ample information about it there as well. CA Day is October 18th at the Seattle Convention Center. I will be presenting on the hot topic of the meetings, changes, open meetings, notice, all that fun stuff that becomes effective on January 1st, 2026 for everyone. So if you want to learn more about that, or you have other interests or just want to network with people, we are now 18 days away. So register if you haven't. As we've been reminding everyone for 3 months, changes to WUCIOA for WUCIOA communities took effect on July 27th. Several provisions of WUCIOA will become binding on all communities on January 1st, 2026. As I mentioned, one of those is meetings. Another one is regarding collection notices. And finally, there was a recent article from the Washington Bar Association on WUCIOA. You can just go to the WSBA.org website. I think they have an archive for their old articles. And this might still be on the homepage, but if you want to know more about WUCIOA, that is another resource. And with that, I think, Ken, you wanted to talk about something before we dove into our questions today.
Yeah, so we have a lot of clients who are concerned about or confused by the requirements which take effect on January 1st of this coming year related to the meetings. So there are, a limited number of sections of WUCIOA that start applying to everybody in January, and Section 445 and Section 502 are the big ones. Those relate to meetings. And there's a lot of confusion about whether or not associations are required to amend their documents so they are compliant with WUCIOA. And the answer is you don't need documents that are compliant. You need your behavior to be compliant. So if you want the documents to be compliant, that's great. And there are many attorneys who are happy to help you. But one of the things I learned this week is that there's at least one non-attorney business entity which is heavily marketing and selling the services of modifying your bylaws to become WUCIOA compliant when they are not licensed attorneys. Now, it's unclear whether or not they are trying to also amend the CC&Rs and declarations because their website is so poorly constructed. For the cost which they are charging, you could get at least some law firms, including ours, to modify your documents to be compliant with WUCIOA. But I'm very concerned that managers are promoting this particular non-lawyer website as a way to update your documents to comply with WUCIOA. And again, you don't need the document to comply with UCIOA, so you don't need to update your bylaws if you don't want. You just need to have the open meetings and the comment periods, etc. We certainly agree that it's easier to do that if your documents match what you're required to do. But please be cautious and look at the services which are being offered. We think that the practice of rewriting declarations which are recorded and affect the property rights of the owners and the association do qualify as legal services in Washington state. And therefore, this particular business would be out of compliance. Basically, they would be practicing law without a license. The business is not licensed with the Secretary of State in Washington state. We understand it might be a Wyoming-based corporation, but it's not licensed in the state of Wyoming either. So before you jump on what looks like an easy way to comply with amending all your documents, please research who it is that's doing the work, whether or not they actually are a licensed attorney, or work with a licensed attorney, and make sure that you don't end up just wasting money on a set of documents which may not actually comply with UCIOA or may not be modified as required by the process for your particular community. So, I don't like that there are businesses who are in a feeding frenzy now, going after the huddled masses who are concerned about UCIOA. We know that some of our competitors are telling the clients that they are required to update their documents, and that is a false statement. They are not required to update the documents. You're required to comply with the law, but you're not required to update the documents. And if you don't have the budget to update the documents, then just find a way to comply with the statute. It's not that complex a statute. You could just print it out and follow that as a guide instead of your bylaws, and you should be okay. So anything you want to add to that, Katie?
The only thing I'll add is something you brought up the other day, which is basically in addition to being careful with non-lawyers updating your documents, I think we've seen an increased use of AI to summarize some of the changes in the statute. And while AI can have positive benefits, some of the summaries that come out of it are flat out wrong. And they don't catch everything. And so just be careful, even if you're using Chat GPT or whatever to summarize Ukiah when you want to use that as, I guess, legal advice. I would be careful there too, because the technology is not probably going to interpret it correctly. So just like you wouldn't use a non-lawyer for legal services, don't use a non-human for legal services.
Yeah, there's at least one law firm that has posted on their blog that under UKIOA, you can call emergency meetings with 7 days notice.
Yeah.
And it is I think it was done by an AI because it has incorrectly mixed up what is considered an emergency and what is considered an unforeseen circumstance, one of which allows you to have a meeting with to give notice to owners with 7 days notice instead of 14. But emergency meetings under the statute can be called with any, quote, reasonable notice. And depending on what the circumstances are, that notice might be, less than 2 days or 4 days. So that's why I think they're doing it. It also is a law firm which is not normally practicing in our area. They're not one which is a member of WSCAI. So, I think that there's also the potential that other law firms are looking at this as an opportunity to get new clients and break into a new business, especially after the Bar Association published this article saying how every one of the approximately 10,000 associations in the state are going to have to start complying with this new statute in January.
Yeah. Well, I think with that, we are ready to jump into our pre-submitted questions. Our first one for today is the annual meeting and the budget ratification meeting one and the same, or are they two separate meetings? And the answer is they're two separate requirements. They can be at the same meeting. Basically, you can have your budget ratification at your annual meeting. Now, if your annual meeting is set by your bylaws for the first quarter of the new year, but you want your dues increases to start January 1st of that year, you probably need to either move your annual meeting or have a separate budget ratification meeting before the end of the year to make sure those dues can be properly ratified and increase. So basically, they can be at the same time. Dues are the same as assessments. They can be at the same time. They could be back to back. Part of the reason you might want to do that is they have separate, they both have the same quorum requirement, but you can still ratify a budget even if no one shows up and you don't meet quorum. If you have no one show up to an annual meeting and you don't meet quorum, then there's no meeting. No action can happen. So if you're supposed to have your election at an annual meeting and no one shows up, there's no election. So you could schedule them back to back. You can schedule them at the same time. You can include in your meeting notice for the annual meeting and have an item on the agenda for the budget ratification and send out your budget. It's really whatever works best for your association. There's no requirement that they be at the same time, just that they both happen, period. Anything to add, Ken?
No, I'm good. So the second question is, we have a developer who has reached out to assist with getting the HOA up and going. They've contracted with an attorney to draft their CC&Rs. I understand that your firm represents homeowner associations, not developers. However, I'm curious if you have a checklist or a series of items that you would recommend a developer include in the original CC&Rs that would be beneficial and save homeowners money in the future. With the upcoming WUCIOA changes, it only makes sense that the developer start with good CC&Rs. Any tidbits or advice for developers wanting to create communities would be appreciated. So we're confused by the question because if you've already got a community platted and formed, then there should already be CC&Rs in existence. It doesn't make sense to us that a developer would come to an existing homeowners association and try and work with or impose new restrictions. But that said, the RCW 6490 in section 225 has a laundry list of what is required to be in a declaration, and that's a starting point. If you're talking about how do you decide what restrictions there should be regarding animals, pets, businesses, smoking, setbacks from property lines, heights, trees, all of those are things which you could look at other communities, perhaps ones which are nearby or similar to yours, to see what their requirements are, because those are not something that are regulated by statute. And then we have assisted a number of developers in creating smaller associations, usually under 10 units. And so if someone had questions about drafting new CC&Rs for a brand new community, we certainly can help with that. We've done a number of very small, usually 2 and 3 unit condo associations. But we've also done, larger ones, and we even did one for airport hangars, which is a little bit unusual. So the developers usually have a different focus because they're trying to make sure that the units can be sold and their interests are protected. And if you look at condominium declarations, especially, there are frequently many provisions which are designed specifically to limit the owner's ability to sue the developer for construction
I was going to pull my chair to the back.
And so those are things which we would normally advise be removed for the benefit of homeowner associations after they've been created. But Yeah, that's about all I have to offer. Anything you want to add, Katie?
No, I think you covered it. So our next question is, does volunteer labor in an HOA fall under WISHA jurisdiction if none of the volunteers receive any compensation? Do OSHA's danger sign requirements need to be followed in HOAs to protect volunteers? So the short answer is probably not, especially if there's no compensation or benefits being paid. For those of you who don't know, WISHA stands for Washington Industrial Safety and Health Act. It's basically the state level of OSHA, which I don't know the acronym, but they regulate safety at workplaces and construction sites, and I think it's like Occupational Health Safety Act. It's the federal government level. So you probably don't need to post signs, and volunteers don't fall under WISHA requirements if there is no personal labor or if the volunteers do not receive any benefit or compensation. And that can be found in the WAC, which is Washington Administrative Code 296-800-100. And they even have a heading in bold that says, does WISHA apply to you? So probably not, but there are some other considerations that this question brings up about volunteers that may be helpful for discussion. So the question of posting danger signs, while you may not be required under OSHA or WISHA to post signs for volunteers, there is a separate duty, completely separate from these acts, to post and warn of non-obvious dangers. So for example, if there is ice under leaves that you know about, you may want to have a sign that says, warning, ice. That's part of the reason you see signs that say like bridge freezes before road. That's because you have basically a common law duty to warn of non-obvious dangers. So if you have those on your property, regardless of whether or not you have volunteers, that may be something to look into. In addition, if you have volunteers, there are some things you want to make sure you're considering and you have protections for, even if, again, there's no benefit to the volunteers. Our primary goal, and yours, is probably that the work be done safely and correctly by the volunteers. And so we recommend that the association have insurance to cover two primary things. One, any injuries to the volunteers, and two, any damage that the volunteers may cause, whether it be to association property, to someone else's property, to themselves. And so that would be something, if you know you're going to have volunteers, to check with your insurance provider to make sure you have adequate coverage, because you want the association to be protected. And it may be that you need some sort of agreement or hold harmless to further protect the association from the acts of the volunteer. Ken, do you have anything you want to add?
I saw a question in the chat on whether or not a general reduction in dues for all members would qualify as a benefit to the volunteer. And I think it would not. If the individual is not receiving a benefit different than all owners, I don't think it could cause this to be swept into compensation that would require you comply with WISHA. You also don't want all of the obligations that a employer would have to train and supervise their workers and provide all of the appropriate safety equipment and to monitor working hours and make sure that volunteers had breaks. And if it was hot out, making sure that they had the required hydration. And I mean, there's a lot of reasons that volunteer boards should not be acting as employers. And that's one reason why often if you do have an on-site employee, they are hired through the management company. So all of those employer duties are shifted to the management company instead of being borne by a volunteer. Anyway, so the next question is, at our last board meeting, the president left partway through the meeting saying he had enough and quit. There seems to be different opinions on whether he actually quit. He was upset, didn't really want to quit the board, just was quitting that meeting. So the question is a verbal statement, "I quit," considered an irrevocable resignation of his board position and or officer position? And I'll offer, it doesn't really matter which of the statutes you're under. The first answer I've got is it's too specific for us to answer this question, but given the little bit of detail, we would say probably this is not going to qualify as a formal resignation from the board. But that's in part because we don't know what the intent was by the person when he said it. If the intent was not really to resign, then it's not going to be resignation. RCW 2403A 525 has a specific section about resignation of a director, and it does state that a director can resign in writing, and it also says a director may resign by giving oral notice to the board at a meeting of the board. And the question would be really whether or not this was notice and what it meant. And we would usually default to, if it wasn't clear they were intending to quit the board by the statement, then it's not going to qualify as a resignation. Anything you want to add, Katie?
Nope. So next is, I saw quorum is not required for secret ballot votes if procedures are followed. Can you please clarify as to what procedure is being referenced? I am familiar with the secret ballot system in California. At that time, we used the signature of the owner on the outside of the envelope as quorum. Will this be similar? So I will say we don't know what California requires, but we did review the statute here and can provide some guidance. So regardless of how you're voting, you need a quorum of participation for an action to pass. What RCW 6490-445 states when it talks about secret ballots is that you don't need a quorum to be present when the secret ballots are physically received by the association, opened and counted, or the results of the secret ballots received by the association by electronic means are reviewed, announced, and recorded in the minutes. So you don't need a quorum present when the votes are counted. You still need a quorum for whatever you're voting on to be effective. And there's no set procedure for validating secret ballots in Washington. You can use what's reasonable for the association. The association does have an obligation to verify that the vote cast was done by an individual entitled to vote for that unit, but that's where the guidance stops. So if signing an envelope, just like how you vote in Washington in general elections and primary elections, works to verify secret ballots, that's great. If you have some other unique identifier system where you can still track who's voting and how they're voting, that's probably also fine. But just going back to the original question, there is a quorum requirement, even if you're voting by secret ballot. The quorum just does not need to be present when you're actually opening and counting and verifying the ballots. Ken, do you want to add anything?
We're good with that. The next question, my association's condo board meets monthly, but most of the meeting time is taken up with committee reports and information sharing. Thus, if there's no motions to vote on, is there no need for an owner forum? We currently have a comment period at the end of the meeting in order to ask for clarification about committee reports. So I'm going to not read all of the question, but the answer is that every association board meeting now requires a comment period at the beginning. So even if you are not going to be voting on something, and even if you're just doing committee reports and information sharing, you would still be required by the statute to offer the owners a comment period at the beginning of the meeting on any subject that they want to comment on. It doesn't mean you couldn't also provide a time at the end of the meeting to offer comment time. The question then it goes on that our executive board meets twice a month. The first meeting is a working session where agenda items are discussed in preparation for the second monthly meeting, but no motions are made, I'm assuming, at the first meeting. In the second meeting, there is no discussion, only a vote on the proposed motions. Owners would have to attend both meetings in order to understand the board's position in order to make informed comments. First meetings generally run up to 2 hours. Second meeting rarely exceeds half an hour. Okay. I don't know if what the legislature had in mind. I don't understand this last sentence, but I'll offer that if you have a executive board meeting, and I'm not sure if that means your full board or you have a subset of the board making it a committee, but if that committee is discussing board actions, then I would say it needs to be open to the membership, and you would need to offer a comment period at the beginning of it, whether you are just having discussion or whether you are just voting or some combination of the two. So we have some clients who create an executive committee, an executive board, or some kind of subset of the board, which is performing some duties, but they are board functions. And so the same meeting requirements would hold. In the same way that any committee which is delegated any board responsibility is required to hold open meetings and have comment periods as well, such as an architectural control committee, or if you had a committee that was, I don't know, dealing with a construction project maybe. So, you know, we can only guess at what the legislative intent was, but we can tell you that the wording of the legislation that was adopted is requiring sort of perfect transparency. They want everything to be done in meetings where owners can show up at the meeting, make comments to the board before the meeting starts, and they get to listen to all the discussion that the board has about a topic, and they get to listen while the board votes on any motion related to that. Okay. So if you don't want to have 2-hour-long meetings, you can try and have the committees condense more of their input to a written form that can be distributed to the committee members in advance. Under the statute, any materials that are available to the board have to be also available to the unit owners. You don't have to mail it to the unit owners, but you have to make it available if the unit owner requests. And I guess if you are concerned about long meetings, if you don't get to something on an agenda, it just rolls over to the next meeting. So, you know, it's going to be certainly a learning process for most of our communities in trying to modify their procedures to comply with the open meeting requirements, the comment period requirements, and the executive session requirements. And we realize that. We also see that the risk for most of our communities, if they are trying to comply or substantially comply, as being fairly small and manageable if an owner is to challenge it. So anything you want to add to that, Katie?
So the only thing I'd add is if you're concerned on whether or not a conversation or an action should or shouldn't be at a board meeting, just have it at the board meeting. Yes, sometimes you have those particular owners who are super involved and they'll show up at every meeting, but they don't get to participate through all the meetings or through the entire meeting. They just get that owner comment period at the beginning. So it as Ken said, it's going to be a learning curve, but once you get used to it, you can make these pretty efficient meetings, especially because you'll probably have to start meeting more regularly so you can cover more things more frequently. All right. Our next question is, under Washington law, what authority do HOAs have to install security cameras in common areas like dumpsters, mailboxes, package rooms, parking lots? And what liabilities can that create for the association? What practical guardrails help with compliance and risk management, such as notifying owners, posting signs, disabling audio, setting clear retention and access rules, and tightening vendor contract terms? So in general, the board has the broad authority to regulate the use of the common elements, and this may include installation of surveillance cameras. We do not recommend calling them security cameras. You don't want to unnecessarily or accidentally create a promise of security. So just surveillance is a better term. But generally the board has the broad authority to do what they want. Some governing documents require owner approval for a capital improvement over a certain dollar amount. So installing something that didn't previously exist is a capital improvement. And I don't know how some security systems can be pretty expensive, so that would be worth looking at your governing documents before proceeding. If you are installing cameras, consider adopting a policy that discusses how long the footage will be stored, that cameras do not guarantee safety, that there's no audio, etc. Because when you're installing the camera and you're retaining footage, you're basically creating another form of association record that needs to be maintained. You need a policy about who has access to the video, when it can be shared. We have some associations that say only the board can access it. It can only be provided if the police ask for it. Some that just let all owners have access to it. So you have to decide how you want it to be used. You don't need to put signs, but you can put signs up. If you are in a public setting, you can have audio, but you don't need it. There's no expectation of privacy for conversations outside in the public, so you don't have to get permission from people before they speak on the audio in most scenarios. So if you're seriously considering installing cameras, it's probably worth contacting your association attorney for more specific advice and direct opinions on how to best proceed for your community. Anything to add, Ken?
No, I'm good. So next question, does collaboration among board members on an association document constitute a violation of open meeting requirements? What guidelines should govern document drafting, editing, and commenting to ensure compliance? So we don't know the answer to this because we don't know what the legislative intent was, and we don't know how a court's going to interpret it. So what we do think is that if you are discussing items, then that probably requires it be done in open meeting. And so if you are sending emails around to all the board members and having email chains where they all talk about something, that probably is a violation. On the other hand, I'm pretty certain that one board member writing a document for presentation to the board can't possibly violate it. And probably one board member sending it to another board member to have it edited before it is discussed by the full board is also not violating an open meeting requirement. And I don't know where the line would be between a couple of board members drafting a document for consideration by the board and it turning into a full-blown discussion by the board outside of a meeting. And until we start getting some court rulings on it, we're not going to know for sure. So I think that if you have an advisory committee, which is trying to prepare a policy on something like collections or pets or investments, that committee can probably do all the drafting and talk back and forth without risk of violating an open meeting requirement. If the policy is going to the full board to then be considered in an open meeting before it's adopted. And if you are using the full board to review documents in advance, then you need to be more cautious, because if you shift to all the discussion happening in the emails instead of discussion happening at the open meeting, you do run the risk of violating the spirit or intent of the law. I don't think there's anything inherently secret about drafting documents. So I don't want to discourage people from trying to prepare documents for the boards to consider. But again, we don't have a clear answer, and that part of it may again come to sort of other variables about how you're doing this. If you're doing it in secret on a topic which your owners don't know about, more likely to be considered a violation. If at a board meeting, someone was to say, we need a policy about security cameras, and one or two board members volunteered to produce it, then I think that you have a very low risk of violating the policy if those board members work on the policy and then bring the full policy back to the full board for consideration. Anything you want to add, Katie?
No, I think you covered it. So our last question submitted in advance, and there are a lot of questions in the chat, so we will get to those in a moment. But our last question submitted in advance is, does a quorum of at least the board members need to be present at a budget ratification meeting for it to be official? And the short answer is no. The meeting needs to be scheduled, meaning the budget ratification needs to be scheduled. But if no one, including the board, shows up, then the budget is ratified. That being said, we don't know why the board wouldn't attend, especially since they set the date for the meeting. Ideally, at least one person would show up to document that no one else showed up or that there was no quorum. If there is a quorum of the owners at any association meeting in attendance, but not a quorum of the board, that meeting still goes forward. So even if you have a quorum of everybody, but not a quorum of the board, you still have the meeting. But if no one shows up, or not even a quorum of the board, that budget ratification still goes forward. Anything to add, Ken?
No, I'm good on that.
All right, and with that, we will go to some questions from the chat. Our first one today is, we are a self-managed HOA. If owners vote for an annual septic inspection, does the board have to vote on the proposal from the septic company each year? Argument being, if it's in the budget, we should not have to vote on the proposal each time. So, not getting into the actual septic inspection, but generally, there is a difference between a budget being ratified and being able to spend the money and who you select to perform that work. Those are two separate actions. The board's ability to collect the money or spend it is different from who you use to do it. And so I would say you could even have it on your agenda every year, but approving who does it, I would say, is a good idea to be voted on by the board. You may have a different board who doesn't want to use Bob's vent cleaning service anymore, or they may have changed their contract or their terms. And while you may have the money allocated, there may be some other reason to reevaluate the proposal. Ken, do you have a different opinion or anything to add?
Well, I guess part of me wonders about whether or not your governing documents require that the association do the septic inspection, or if that's part of the management by the association. We've seen some screwy CC&Rs where the association's responsible for the individual owner's septic tanks, which made no sense to me, but it is what the document said. But yeah, I would agree that the board has the responsibility to vet and hire individual contractors. And that's different than the association telling the board that they want the inspections done. So it sounds like the membership is voting to have inspections done, and then the board has to make the decision about the vendor to choose and hiring them.
All right. Our next one, which I think I'm going to let you start with, Ken, every other. We have a 2026 budget ratification meeting on Sunday. Owners have received a meeting notice. Is there a requirement to send the agenda prior to the meeting? The budget was included in the meeting notice, but no, it looks like no actual agenda for the budget ratification was included in the notice.
Well, I'd have to see the actual notice to give legal advice, so this isn't legal advice. But if you send a notice which said budget ratification meeting, I think that is the agenda. And I don't think you would need to separately send an agenda that says you're going to, establish whether there's a quorum or not, and then you're going to ratify the budget. I don't think a court would say that if the owners were told they're coming to ratify a budget, that a failure to give an agenda item for that was going to cause a failure of the notice. You wouldn't be able to conduct other business. So you couldn't decide at the same meeting you're going to hold an election, even if you had a quorum. You couldn't decide to vote on whether or not to avoid a CPA audit, even if you had a quorum, because those items were not on the agenda. And you certainly couldn't choose to remove a board member, even though some bylaws say that a board member can be removed at any meeting. And that's in part because the statutes require that you must give specific notice about the agenda item to remove a board member, and the board member has to have an opportunity to address the community before their vote can be taken. So, anything you want to add?
Nope, I think you covered it. So our next one is, and I accidentally just minimized, if the board is holding meetings without notifying the owners, and I'm assuming this is under the new meetings requirements, are the decisions made during these meetings in jeopardy, such as being thrown out if challenged in a court? There do not appear to be consequences if a board fails to follow the law, such as an open meeting requirement, or did I miss the written consequences by the lawmakers in Olympia? So there are, I would say, consequences if the board doesn't follow the procedure, but there's also a bit of a saving clause for the board. So as Ken mentioned, if the board is acting basically in good faith and making a real effort to actually follow these procedures, some accidental mistakes can be corrected. So first, if there's no open meeting requirement and a decision's made, the most practical way to fix that would be just redo it at a meeting that follows the procedure. RCW 6490-4452L does apply if basically an action is taken improperly by the board at a meeting. And it says, even if an action by the board is not in compliance with the meeting section, it is valid unless it is set aside by a court. An action seeking relief for the failure of the board to comply with this section may not be brought more than 90 days after the minutes of the board meeting at which the action was taken are approved, or the record of that action is distributed to the owners, whichever is later. So basically this means if the board messed up January 1st, 2026, didn't have an open meeting, sent out the minutes of the meeting, and no one and recorded them and published them and everything, and no one did anything for 90 days, whatever was done at that closed meeting January 1st stands. But if within those 90 days from when the minutes are published or distributed, an owner challenges that action by the board and basically has to file a lawsuit to ask a judge to set aside the board's decision and make them comply, then that's what would basically undo the board action. So it's onerous on the individual owners, but it's also pretty easy to correct an action improperly done. Like I said at the beginning, you just hold a meeting in compliance and redo everything. Ken, do you want to add anything to that?
Well, I'll just try and provide an example. So let's say the board was to change their fines. and they've changed the fines from $50 to $100. And they did it at a closed meeting. And they did send out notice to all the owners of the fines. And they had at a second meeting, they had approved the minutes of the previous closed meeting where they had adopted fines. So they've met the two conditions, and the latter of those two starts the 90-day clock. So if an owner didn't challenge the new fine schedule within the 90 days, then it will be effective and it could not be later challenged. And I'm pretty sure that this was to avoid procedural challenges to decisions that boards are making long after the fact. 90 days seems like a short time to me, but it is what the legislature picked. But the 90 days doesn't start until owners have been given, formal notice of whatever decision it is that the board made. So it is the provision, I call it a savings clause. It's not what the legislature calls it. But it is what allows the board to make mistakes and get away with it, as it were. What I don't want is for our clients to look at that savings clause as a way to avoid all of the requirements for open meetings and comments and intentionally disregard the legislative intent of open meetings and transparency.
All right. Moving on to a question about fiduciary duty and investment of reserves. Is it true that a licensed fiduciary is required in order for the association to invest their reserve funds? Does the board meet the requirement as the fiduciary by nature of their responsibility? So I'll answer a tangential question, which is basically, is a board member a fiduciary? And generally the answer is no, but Ken, I think you have a lot more experience with fiduciaries and investments if you want to talk about this more.
Well, I'll say a couple things. One is that the board may have a fiduciary duty, but that is a duty of ordinary and reasonable care. It is not the duty of a fiduciary, which is separately defined in other statutes. In terms of investments, the statutes, especially WUCIOA, are better at stating what specific investments you are allowed to have, which would not require any kind of investment advisor or a fiduciary. So you can invest in any federally insured deposit accounts, which would include CDs at your bank. You can invest in any security issued by and backed by the US government. So you can invest in treasury bills and treasury bonds because they're backed by the US government, even though they are not insured by the US government. There's a section in WUCIOA that would allow a board to invest in mutual funds or non-insured, non-secured investments. And it requires that you have more than $250,000 in reserves. So the first $250,000 cannot be invested in anything that has a potential risk of loss. I believe you can't invest more than 50% of your reserves in those kinds of investments, except that there is a provision that says that if 75% of your membership approves investing more than 50% in mutual funds, then you are allowed to do so. But then the statute also goes through and says that to invest in anything other than those insured or US-backed investments, you're required to have an independent investment advisor and a fiduciary investment advisor, meaning one who has to look out for your best interests, probably would meet that portion of the requirement, but that's not the only requirement for doing investments in risky assets or ones which may have a higher rate of return. So if you're a WUCIOA community, then you have some options for investing in securities. And you have to look at that statute, and you may want to get advice from someone other than the stockbroker trying to sell you investments.
All right. Thank you. So we had several questions in a row that are too specific for us to answer in this forum. If you want to send them to info@condo.law and maybe rephrase them for next week, that is an acceptable option. So if you don't hear your question read and I'm reading one that came after it, it is because we can't answer the question right now. So don't be surprised. So our next question is, are meeting minutes required to be mailed to all owners? Is posting to a homeowner portal or sending it by email blast sufficient? And I would say, as we just talked about for when we were talking about that 90 days of notice of when an action was taken, in my mind, when the statute says notice, it means notice in accordance with your governing documents. And so if your governing documents require notice to be sent via mail, or some people have opted in to receive email notice, that's how I would read the statute, is you need to send it out for that to apply. The posting it to an owner portal, we've actually had this question come up before. There's no clear answer, especially if the portal, I mean, it's an easy answer. If the portal doesn't notify anyone that there's something on the portal, then I would say there's no notice. But if you send an email or a notice that says we posted the minutes on the portal, that may be sufficient. I mean, the least risky option would be to mail it and send an email blast. But there's no clarity by the legislature on what would be enough. Ken, do you want to add anything?
Yeah, so the notice provision of the statute says that if you want, if you have to give notice to the owners and they've agreed by email, then you can just send an email that says, we have posted the document on the website, and that satisfies it. But if you have owners who've not agreed to electronic notice, you would need to mail it to them in order for it to be notice. And, there are going to be some, I would say board meeting minutes are not usually what I would say you have to give notice to all owners about. If you've taken an action like adopted a new collections policy or a new set of rules, those need to go out separately from the board meeting minutes in most cases. So that's what I would focus on, making sure I gave adequate notice to the individual owners, whether it's by posting it on the portal and sending an email saying, here it is, or by mailing it to those who have not agreed to electronic notice, or by mailing it to everybody. Because certainly it's going to depend a little bit on how much risk you have for the thing you're doing. So if you are going to mend your rules about collections, those have relatively high risk. Our office wants to make sure you have, without question, complied with the notice requirement. So we would want to see you mail it to everybody, even if it's not required, because that's the safest for both the association and the law firm if we get into collections on a particular matter. If it's something else, the board's decided to, put Christmas decorations up at the entrance to the community, and that happens at the November board meeting, I don't think it's going to matter that you do or do not give the notice to everybody. We do think it's a good idea to be posting things on web portals. It's one of the easiest ways to make sure that the documents you're required to keep and provide are both kept and available to the individual owners. So we're generally in favor of not open websites, but websites that are open to the members of the community.
One more related question on that is, I email the board minutes a day or two after the meeting. the minutes are not adopted until the next meeting, what is considered the start date? I'm assuming for the failure to comply, because it's 90 days after the minutes of the board meeting at which the action is taken are approved, or the record of the action is distributed to the owners. If the record of the action is distributed to the owners, and the statute says whichever's later. So if the record is distributed to the owners and then the minutes are approved, the minutes being approved would be the later date. If you don't send the minutes out to the owners or post them on the portal until after they're approved, then that would be the later date.
Yeah, I'd say the statute's pretty clear. So if you're sending the minutes out 2 days after the meeting, and then a month later, you're sending out another set of minutes, which approves the ones the month before, 90 days after the approval.
All right, and as I mentioned earlier, there are several questions that are too specific. Just if you're thinking of resubmitting them for the Q&A next week, questions that are too specific are questions that require us to look specifically at your governing documents. And so whether or not someone's allowed to do something, or if someone's required to do something under a certain committee, or if they're allowed to install something, those are probably going to be too specific without us looking at them. So if you can try to rephrase it to be more general, then we can try and answer it. But otherwise, those are best suited for your association attorney or an individual attorney. And with that, there are no more questions that we can answer generally at this time. So I think we'll give everyone 4 minutes of your morning back. Thank you for joining us today, and we will see you next week.